So I was saying that we have the screening of Diosa, this movie, here in the Garden Cinema. I really recommend you this movie's theater, which is beautiful, just in the corner near Holborn Station. And on Tuesday, March the 5th, we will talk about Queen of Spain, Victoria Eugene, the granddaughter of Queen Victoria, with the curators of the exhibition about her taking place in Madrid's Royal Collections Gallery until April the 5th. I really recommend you this event. This exhibition in Madrid introduces the figure of the Queen and pays tribute to her contribution to Spanish society. So we will have this also some British speakers together with the curators of the exhibition in Madrid. So don't miss it, because we have just some few seats available. And on Friday the 20th, we have Elvira Lindo, the Spanish writer. She will be here in conversation with Professor Maite Ushoz. And on Sunday 22, Elvira Lindo will be in Oxford Literary Festival in a very special concert with 4 musicians at the festival, Sunday 22 at 4 p.m. Also really, really recommend this event in Oxford. And thank you all. And I'm just giving the floor to Christina. So thank you again.
Thank you, Victor, for hosting us at this event in this amazing place. Well, you say in a suitable place in Temple. Thank you, Jorge, for all your help to prepare the event. We are delighted to welcome Professor Javier García Oliva. Javier is Professor of Law at the University of Manchester. He's currently the head of law at this institution. He is a lecturer in Spanish law at UCL and Oxford. Furthermore, Javier was the Robert Campbell Visiting Fellow at Magdalen College, Oxford, last term. He specialized in issues of constitutional and public law and human rights, particularly in relation to freedom of religion and belief. He has written extensively on the concept of constitutional culture. Javier studied graduate master's and PhD degree at the University of Cardiff and worked at the University of Cardiff and Bangor before joining Manchester. We also pleased to welcome Reverend Professor Helen Hall. Helen is a chair in law at Nottingham Trent University. Her research concentrates on law and anthropology, toward history of law, and issues concerned with belief and identity. She studied law at Peterhouse, Cambridge, theology, anthropology at Durham University, and completed a PhD with Cardiff University. She's an Anglican priest and a solicitor not practicing. Both Javier and Helen are currently working on their third joint book on law and the supernatural. Their previous book, Constitutional Culture, Independence and Rights in Science from Quebec, Scotland and Catalonia, was published by University of Toronto Press in 2023. In this event, Javier and Helen will help us to unpack what the law can tell us about a society and how constitutional traditions influence the way we think about rights, authority, and identity. After their interventions, we will open the floor for a 10 minutes Q&A, and our 2 speakers will be very happy to answer any question from the audience. After the Q&A, we will have time to have a drink and continue the discussion. Now, we just start with the presentation. So, Javier, please.
Buenas tardes a todos. Es un auténtico placer estar hoy aquí con todos vosotros. Thank you very much for this extremely kind invitation. I'm really humble and honored to be with all of you today. And needless to say, I would like to start showing my appreciation to Víctor Ugarte, director del Cervantes, to Jorge Garrez, cultural coordinator, and to Cristina for having kindly provided me with the opportunity, or provided us with the opportunity to be with all of you today. And thank you very much to all of you. There are so many other things you could be doing. on an evening like this rather than being with us. Therefore, I do not take it for granted. I'm absolutely delighted to be with all of you today. As Christina has mentioned, and before I start, I would also like to thank Mar, my colleague and friend from UCL, and to my wonderful students from UCL who are here today. It's so good to see you all here today. Helen and I have been working together for a very good number of years. I am a constitutional lawyer, and Helen is a private lawyer, particularly in the fields of family and tort law. Out of interest, how many of you have a legal background? Wow. That's therefore I assume many of the things I'm going to say you already know, or you may disagree with my take or our take, and this will give rise to an interesting discussion later today. Helen and I started working together because we understand the legal system as a very complex reality where we cannot just detach the public law from the private law dimension. And on so many occasions, obviously, you need to tackle one particular question, bringing together constitutional law, contract law, family law, etc. That was the beginning of our collaboration. And we've been now working together and I'm very honored to be working with Helen in so many projects, including our last project, which is very different from what we did before, Law and the Supernatural. It's very exciting, and we are now writing it down, and hopefully we'll have perhaps one day the opportunity to discuss our findings with you. Then our last book was on independence and sovereignty. We were looking at Quebec, Catalonia, Scotland. That was obviously very interesting. Autonomy, identity, sovereignty, culture. But now we have moved to work on areas such as witches, fairies, exorcism. Law is fascinating. This is the point. It's so diverse. It's so exciting. And for those of you who don't have a legal background, I do remember before I did the law degree, I was always told, I was told by quite a few people, why are you choosing law? Law is tedious, law is boring. Well, I think my professional life has taught me the opposite. It's a really exciting discipline. Then, in the course of today's presentation, so if I may, we're going to, sorry, I don't, yes, that's there now. We're going to be looking at the whole notion of constitutional culture to start with. And that has been the scope of our research in the course of the last few years. And once I discuss this matter, I'm going to draw some comparisons between the so-called civil law and common law traditions. And obviously, we're going to be looking at Spain as an example of a civil law country, but Spain belongs to a wider family, and we share so many features with other continental European countries like France or Germany or Italy. And the same can be said about the common law family. England shares so much with other countries such as Australia and Canada, etc. Then we'll be looking at the whole issue of codification, because one of the main distinctions, obviously, between Spain and the UK is the fact that we do not have in the United Kingdom, as we know, a codified constitution, and what that means in practical terms. We'll be focusing on that. But I think probably the most important part of our presentation is providing you with some examples about how the law responds differently to different situations in both jurisdictions. Then we're going to be looking at the duty to help strangers, the whole notion of bodily autonomy, wills and family expectations, insults, rumors, and reputations, and buying a house. It's a variety of themes, as you can see there. It's rather ambitious, let's me be completely honest with you, but we'll do our utmost, because at the end of the day, the most important part of this presentation is not so much what we're going to tell you, but I am very excited about hearing from you what you think about all these matters. Then in terms of constitutional culture, the important element here, and obviously we've written on that, I'll try to summarize, is the whole idea that law cannot be understood, never, ever, in a vacuum. Law is part of a much wider reality. It's a critical tool, but it has to be understood in a much wider context. That Helen and I label as constitutional culture, rules, norms, and expectations that govern collective life within a jurisdiction. And we love metaphors, both of us. We always use them. I think they help our students, but I think they help us all in general. We would say constitutional culture is like a hard-boiled egg, in which if you think of the yolk of the egg, that would be the legally enforceable part, obviously the legal rules, which are legally binding, whilst if you think of the white of the egg, technically known as the albumen of the egg, that would be all these collective social expectations that surround the legal system. Well, as we can see, law is not really something that can be understood isolated from the rest of our society, and that's why the wider constitutional culture shape the legal system. Let me just give you two examples. I would say that generally speaking, religion in the UK, the political and legal authorities historically, but also in a contemporary sense, regard religion and belief, wider belief, as a positive reality. Then that has an effect clearly on our legal system. And there is a plethora of examples, it's not the scope of today's presentation, about how the legal system of England and Wales and the wider United Kingdom is very supportive of religion. And faith schools is a very clear example of that. This is very different from other jurisdictions, as we know. Sports. The whole idea, the notion of sports, is also something which is very much favored and supported by the legal system of England and Wales. And for instance, during the pandemic, some people were horrified, but the public authorities were far more lenient towards the practice of sport than about other realities, because there was this general expectation in our society, or this common belief, shared belief, that the sports are beneficial to us. These are examples of that wider, the albumen or the white of the egg. The extra legal elements of constitutional culture are important for lawyers because it's impossible to understand the operation of the law without them. First, they make a huge difference to concepts like reasonableness and risk. There is obviously a definition in the dictionary of these terms, but what do they really imply in practical terms? For instance, the whole notion of significant harm. As you know, in our jurisdiction here in England, as you know, in legal terms, sometimes I say England, sometimes I say the United Kingdom. It's a bit tricky because for some matters, in terms of, and our law students know it very well here, for some matters in terms of private law, the Scottish jurisdiction is very, very different from us. Public law, which is the area that I teach, I always tell our students we have to keep saying British public law because it's the law for the whole of the United Kingdom. Then please forgive me because at times I will say British law, at times I will say English law instead. What does really mean significant harm? How can we interpret it nowadays? Can we interpret significant harm in 2026 in the same way we did it 3 decades ago? Certainly not. Local authorities in England and Wales have a right and a duty to intervene if a child is suffering or at risk of suffering significant harm. But certainly, I would say, things have changed, and the whole notion is very, very different nowadays. 30 years ago, you could still hit children with an educational purpose and so on in this jurisdiction. Nowadays, you can still do so as long as you don't reach the actual bodily harm threshold. That means that if it gives rise to a bruise, that would be unlawful. If 30 years ago, significant harm would have been something very, very different from what significant harm is nowadays. But even within the United Kingdom, there are striking differences between England, where this is still allowed, and the Welsh jurisdiction, where any sort of corporal punishment is absolutely prohibited. Therefore, the law cannot be understood, once again, in a vacuum. It's part of this much wider society. We are, for another example, we're now much more conservative about the age in which children can be left alone. 30 years ago, it was absolutely possible to leave a child. I would say, well, I was a child then, but it was much more possible to leave a child by himself, by herself. Things have changed nowadays. And what is a significant harm, what would be dangerous for a child, has certainly changed. Therefore, the whole notion of our societal expectations is absolutely critical to interpret these legal terms. Second, it's also key to understanding the way in which law is enforced or not in practice. And this is a very interesting example, I would say. The Licensing Act of 2003, Section 141. It is a criminal offense in this jurisdiction to sell alcohol to a drunk person. You're all smiling. I think my students also smile when I teach this area in Manchester. It's quite an interesting one. But I would say, what is happening with the law? I would say that a Martian visiting London on a Saturday night would probably not guess that this was part of the legal possession in this part of our planet. Why do we have, therefore, this law? I think sometimes the law is there to enshrine the sort of ideal values that we all share, at least in theory. Okay? Then the relationship between law and culture is therefore highly complicated, and it's always a two-way exchange. And I think this is very important because sometimes we tend to think that law is always dragging behind society. The society changes and then the law responds. And I would say that that can happen, but also on many occasions it's the opposite reality. On other occasions, the law is the driving force that changes people's minds, and it's happened with lots of legislation concerning, for instance, discrimination on grounds of characteristics like race, sexuality, etc., which have been very influential in reshaping social attitudes. I do believe in law. I always find this whole, and I know the law sometimes fails us, but I always find it very disappointing when I see some of my peers or friends thinking that law is just a very reactionary force, because on many occasions, law is the opposite. And we tend to have this view of law as something that prohibits things, that prevents us from doing things. And I would like to also claim that law is something far more positive. Law also enshrines our collective values. Law clearly shows what we share as a society. Laws do set out the limits on behavior, of course, that will be tolerated and punish those who transgress, as I have just said, but they are not simply coercive. Laws also enshrine positive values. I've been doing this research recently, and Christine alluded to that in Oxford for a semester, and it was just mind-blowing reading the Magna Carta and its impact on the values that we share nowadays in Britain in the 21st century. And I would say that similarly, an example I can think of Spain, the Spanish Constitution recognizes the special place of the Roman Catholic Church in the history, culture, and life of the state, but very deliberately stops short of making it the established denomination. Then once we have looked at the whole notion of constitutional culture, if I may, I'm going to move on to the second part of our presentation, which is the theoretical distinction between civil and common law. As I said, many of you have a legal background. I don't need to tell you, but I think for the benefit of everyone, I would like to make a distinction between civil law and common law. Civil law, obviously, where Spain belongs, it is based on late Roman law and its principles. Common law, it is based on the legal systems that evolved in England and Wales after the Norman conquest in 1066. Common law traditionally relies heavily in precedent. Cases are very frequently reported, and there are rules about when and how principles are followed and developed. The influential status of reported cases in civil law systems doesn't really work like that. Therefore, very, very different mindset to start with. Of course, I think this distinction shouldn't be underestimated, but at the same time, it is quite fair to say, and we're going to be illustrating or drawing comparisons between these two jurisdictions, and we're going to be looking at differences. But I wouldn't want us to think, oh, we are all, because what is happening at the same time is that there is a convergence. And in many, many ways, the Spaniards and the Brits, and the French and the Germans, and the Canadians and the Australians, we are all becoming, in some senses, much more similar one to another than we were. The truth is, however, that I think it's fair to say that in the civil law systems, they tend to be far more detailed, and there is this emphasis on codification. Therefore, there is a bit of truth when we claim that there is a higher degree of rigidity, whilst the common law systems, on the contrary, embrace much broader principles with a higher degree of discretion and interpretation. For instance, and this is very funny because I had this friend of mine who went to, I think, let's not say the continental European country, just to avoid offending anyone, but he went to a continental European country, and then he saw that there was a very, very detailed list of things that were prohibited to carry on a bus in a given city in beautiful continental Europe, including probably fish tanks. Because if you carry a fish tank, obviously you can be put in somebody else's, not life perhaps, but well-being in jeopardy or at risk. Well, we would never do that in England. We would never do that in the United Kingdom, because that wouldn't be a very British way to do things. I think common lawyers would not specifically mention that carrying fish tank on buses is prohibited. They would say you cannot carry things that are going to be annoying or harmful or disrespectful towards other passengers. Then in that sense, I can see in many, many ways, as much as I love Spain, my home nation, with all my heart, I have found studying British law, I must say, very liberating throughout my career. Because I think in that sense it's very, very different. Then sometimes they really diverge, but as I said, they will also provide you with some examples of how in some senses they are also becoming closer. But this is why I was at pains to stress earlier that the United Kingdom is such a diverse state, plurinational state, to our fortune, with different families, different nations, because I would argue, or we would argue, that Scotland is hybrid. It's not strictly speaking civil law, certainly not, but it's not common law in the same way as England and Wales. And I would say that's the result of Scottish history, where for many, many, many centuries, there was a strong connection between the Scottish nation and France. But, I mean, that's obviously debatable, as so many other things in the legal system. Then, but interestingly, whenever I say to my Spanish friends I teach British constitutional law, many of my friends or peers tell me immediately, Javi, there is nothing as such. The Brits or British people don't have a constitution. There's not a constitution in the United Kingdom. And not only Spanish people, interestingly, when I start teaching first years, in the first lecture, many of my students, most of them British, will tell me, no, we don't have a constitution in the UK. Then the purpose, the aim of my presentation throughout the first 2 weeks is explaining that obviously in the UK we have a constitution, but it's not a codified constitution contained in one document as it happens in the vast majority of countries on earth, and certainly in every other country in our European continent. But I would agree with David Feldman, who is an outstanding scholar, professor of public law at Cambridge. He's now retired, but we have been fortunate enough to appoint him as an honorary professor in Manchester, and I see him loads, and he's brilliant. David Feldman always says that this difference between codified and uncodified sometimes is exaggerated, given that both uncodified constitutions have important written elements and codified constitutions have important unwritten elements. And for instance, the right to bear arms, the way it's generally understood now within the United States, is certainly not obvious from the text of the Second Amendment read in isolation. Therefore, this idea that we countries with codified constitutions, everything is there, and we don't need to worry about the unwritten elements and the wider society is also wrong. Also, to understand the Spanish Constitution, we certainly need this wider albumen I was referring to. Nevertheless, there are differences, and I'm going to illustrate it by referring to the monarchy. I think the UK Constitution leaves many more matters vague. Some of my students say, well, this is where can I find the appointment of the Prime Minister? In which statute, in which provision? I have to say, I'm sorry to say, it's easier for my Spanish students. They go, obviously, to Article 99 of the Spanish Constitution. We cannot do that in the UK because, as we know, it's a prerogative of His Majesty the King, but limited by this convention. Then, even though the king can appoint whoever he pleases as his prime minister, when it comes to the crunch, he's not going to do so. He will be appointing the person who may command a majority of seats in the House of Commons. Then it's very, very interesting. I would say, therefore, that I'm not saying that studying constitutional law in Spain is easy, but at least it's more straightforward because you have the constitution there, and then it makes it a bit more. No, I'm not saying it's easy, but I would say that it's more, let me leave it there. It's more straightforward. But then in the UK, we have this distinction between the real and the legal and the real constitution. Then even though the king can do whatever he pleases, the real constitution means that he's not going to do so. And the country, in practical terms, the decisions are made by the prime minister and so on. Well, if you look at the Spanish constitution, we have a title, Title II, on the crown, where the powers of the monarch are detailed. Then the whole notion of could the monarch withdraw consent or assent, royal assent to the legislation, is an ongoing area for us because the monarch of Spain cannot do that. And then if the student is very bright, and my students are very bright, they will say, yeah, but there was an example, for instance, a few years ago with the King of Belgium. You may remember Baldwin, when he didn't want to give his assent to the enactment of a piece of legislation concerning the right of abortion. Yeah, there are those instances, but it's very, very different. Then in that sense, I would say, let's not exaggerate the distinction between codification and non-codification, but the distinction exists nevertheless. And I'm going to, therefore, before I hand it over to my co-author, Helen, I'm going to refer to these practical examples now between the UK or England at times and Spain. Then let's start with, I'm going to be looking at duty to help strangers and bodily harm. And then Helen will take over and will be looking at family relations and property law, etc. You will thoroughly enjoy because she's an outstanding speaker. Then let's start with the duty to help strangers. This was something that I really found striking when I first arrived in the UK. Because in the UK, we don't have this duty, okay? To me, it's a bit bewildering, but let's leave it there. In Spain, there is a duty to assist. La omisión del deber de socorro, as we know, is a criminal offense. This is very, very interesting. Then I don't want to bore you with the text, with the wording of that article, but Article 195 is very clear. Whoever does not assist a person who is unprotected or in serious manifest danger when able to do so without risk to himself or third parties shall be punished with the penalty of a fine of 3 to 12 months. The same penalty shall be incurred by whoever, being unable to provide assistance, does not urgently call for outside help, But if the party concerned is the victim of a fortuitous accident caused by whom omits the assistance, the punishment shall be 6 months to 18 months imprisonment. And if the accident was due to negligence, 6 months to 4 years. We are not just talking about financial punishment. In some important cases, obviously, there will be life imprisonment. Well, this is very different in England and Wales. In England and Wales, obviously not the last example I've given you earlier, because that's a different matter, but in England and Wales, not only is there no criminal duty in the absence of some relationship or assumed duty, there is not even civil liability for a failure to render aid to a stranger. Why is that? And I would say, and this is my reflection that I will share with you at the end of today's presentation, I think that this reflects that in our society, in British society, there is a more libertarian and individualistic approach to society. But I understand these statements are always vague and perhaps slightly unfair, and I am very much prepared to be contradicted or for you to disagree with me. Does this mean that in England we don't care about people who are dying? No, I think that would be a bit much. I would say the opposite. I would say that that's not really true. Certainly, there is a different attitude towards the function of law in Spain and in England. But I would say that if a stranger callously chew a sandwich and watch an elderly person who is slipping into a shallow pond drown, rather than helping, I think people would be equally appalled here in beautiful London, in Newcastle, than in Madrid or Cadiz, my hometown. In that sense, what I want to say that accepting a social or moral duty, I think we have that moral duty in the UK. I think otherwise I wouldn't have been living here for more than 20 years by now. But there is not that legal norm. And I think that there is a sort of dissonance over there. This would be one example about how the law in Spain and England differ from each other. The second example I wanted to share with you before I hand it over to Helen is bodily autonomy. Both of us, the United Kingdom and Spain, belong to the wider European family, at least for the time being, and I hope forever. Also, the UK is part of the Council of Europe, and we embrace or recognize the importance of the European Court of Human Rights and also the European Convention on Human Rights. That, as you know, we were one of the countries here in the UK that was instrumental and critical in the signature of that document in the early 1950s. Anyway, the European Convention on Human Rights is Article 8, recognizes the right to private and family life, which includes also the right to bodily autonomy. What does that mean? Because that's the supranational concept, the supranational dimension. What does this mean in practice? Well, that varies considerably. In both cases, if we go to the extreme cases, obviously touching someone in a way that causes injury or has a non-consensual sexual dimension, that will be unlawful, rightly so. But what about other forms of touching? What happens with the other dimensions of touching? Well, in England and Wales, touching another person is both a crime and a tort. And this is something that perhaps many British people don't know, because why would they have to know? But it's not, it can be a crime unless it is done with consent, express or implied, and it is part of ordinary social interaction. If I keep touching somebody, like jokingly all the time, that will trigger liability. You are smiling, but leave me alone. Well, that would be definitely an opportunity for the law to bite. When I mentioned this to my Spanish friends, a lovely friend of mine, a lawyer who unfortunately I lost 3 years ago, he was very, very, very bright. And he would say, Javier, are you serious? Are you telling me that in England that would give rise to liability? Yes, it does. It's very, very different. That you wouldn't find that in Spain. I have deliberately chosen then examples where in one country it would be trigger, in the previous example in Spain, and here, on the contrary, not in Spain, but in the UK, then when we say we're all the same, and well, we're all the same, but to our fortune, I would say, we maintain very legitimate differences in our approaches, and I think that's what makes the whole family much more exciting. I'm going to hand it over now to Helen. Thank you very much for listening.
Thank you, as always. And I won't repeat everything and ruin the flow, but can I just say how grateful I am to be here as well, and how grateful I am to work with Javier too. So I'm going to talk about some provisions primarily of private law. And being a private law lawyer, I can't do anything at all in life without giving you a health warning first. I think there's a kind of unofficial union of tort lawyers that would throw me out if I did. So I'm going to talk about the broad brush principles, because as we've been talking about, we're thinking of trends within the patterns of the legal system. So when you get into the granular detail, it might be that there are some particular exceptions that buck the trend. Does that make sense? So we're looking at the general way in which the law is flowing. And another area that tends to cause surprise, both for lawyers and non-lawyers, are the different attitudes to what we might call testamentary freedom. That's absolutely fine. Sorry. Oh, that's so sweet of you. Thank you. That's really kind. So essentially, there is the classic proverb, you can't take your property with you when you die, you can't take it with you when you're gone. But in England and Wales, you can jolly well decide who's going to get it. You might not be able to take it with you, but you have got the freedom to decide basically who gets your stuff. In contrast, within the Spanish system, there is much less freedom. Yeah, do come in. It's honestly fine. No, it's lovely. It's a really nice, welcoming space. So, yeah. So, obviously, in both cases, there is a little bit of nuance to this. So, in England and Wales, generally speaking, you can leave your property to whoever you want to. There are some restrictions as a result of the Inheritance Provision for Family Independence Act, 1975. In some circumstances, if people have become dependent, and also case law tells us the same thing, there may be times when there can be some exception to it, but it doesn't spring up just because you have a biological relationship with another adult. That's not a good enough reason to tie down your ability to decide stuff them is going to the donkey sanctuary. And in England, it very often is donkey sanctuaries, and that's a good thing. I'm very fond of animals. There is a certain irony in it as well, of course, because you are more likely to be able to successfully challenge a provision disinheriting you if you have been dependent and relying on the person who's died. So in a way, the less you do for your adult children when you're alive, the less you have to do for them when you're dead. So you can make of that what you will, really. Obviously, of course, this is different if you're dealing with minors. Even in this jurisdiction, we do have some limits and some sense of decency. In contrast, the position is very different when we are thinking of Spain. Effectively, I mean, this is a great example of codification and slightly nuanced codification, but effectively estates are divided into three portions. The first portion, there are quite strict rules. There are obligatory heirs to whom it must go to. Or perhaps I would prefer to say obligatory beneficiaries, because heir can have certain connotations in English, and some of the lawyers will agree, and those of you who aren't non-lawyers will probably think I'm being pointlessly pedantic, but anyway. Secondly, again, the second portion of the estate, there is discretion, but within some quite strict parameters. So you have a bit more flexibility, but you still have to leave to certain obligatory beneficiaries. And then the third part can go to the donkeys or to other human beings or where you choose. So you can see that there's not complete rigidity in Spain and there's not complete freedom in England and Wales either. But if you look at the general drift of the law, the expectation, the centre of gravity in England and Wales is one of freedom. You can choose what to do with your own stuff. Whereas in Spain, it's no, you're part of a wider family structure, and that family structure will be taken into account in what you are permitted to do, and more to the point, what you are not permitted to do. And arguably, not only does this reflect different traditions of law, and I think there is an element of that, but I think it also reflects differing attitudes to relationships and community and how we see family life. Now, for instance, again, I think things are changing in both jurisdictions, particularly, and economics has played a part in that. But I think still now, it is considered more unusual and less likely to be a free choice if an adult, say in their early 30s, is living at home with a parent. It does happen, but I think the social assumption is that will be for economic reasons or that will be for a health reason on somebody's part or another. Whereas I think in Spain and Spanish families, it's much more likely to be but this suits everyone. I'm not in a relationship at the moment, and why wouldn't I want mum and dad to carry on cooking me? They make the best meals. They know exactly how I like my pisto or tortilla. What would possess me to go elsewhere? Um, so I think you could perhaps think that maybe there are these wider social forces that influence, because after all, it's not as if either jurisdiction got frozen in time. Both of them are democratic systems that could change the law. If we've chosen to leave the law where it is, that suggests that it makes sense in terms of the social context. If we're not making a big fuss, that we're not terribly unhappy about the law. It's interesting too that it does reflect different attitudes towards property, so keeping property in the families and also the things that you think are priorities. So, for instance, the law of trusts developed special exceptions and special rules against the, generally speaking, we don't allow you to tie up property forever and ever. There are exceptions for things like charities, but we also carved out exceptions for things like tortoises. So that pets that might live longer than the average human life, we made special provision for, because that was something that was felt to be important. Never let it be said that interesting things don't come before. I was about to say common law courts, but I think at those times that they began to be carved out, it might still have been the Court of Chancery. So moving on to insults, rumours and reputation, because I'm sure something that both this jurisdiction and Spain and quite a lot of the rest of human beings like is a good gossip and also complaining about people we don't like very much. I think that's a human facet for as long as we've had language, right? How do we deal with it, though, when it goes too far? And at what point do we? Now, again, this is quite broad brush. And both, again, as we've heard, brilliantly explained by Javier, both contexts, of course, are part of the framework of rights that we have from Strasbourg and the European Convention of Human Rights. We both places, therefore, recognise the importance of freedom of expression. And therefore, taking away and punishing people for saying things that we don't like isn't something we do very readily. However, when we consider it's appropriate to punish expressions, I think there's a different philosophy. So to me, it's very interesting that Spain has a recognised right to honour within Article 18 of the Constitution, and that this is backed up by both civil and criminal mechanisms. The concept of a right to honour is really not something we think about. It's not how English lawyers would see the world. And there are various mechanisms. We have calumnia, we have injuria, They operate in slightly different ways. The first deals with the false accusation of a crime. The second deals with expressions that are an attack on dignity, reputation, or self-esteem. Again, I'm not really sure that in the law that we have in England and Wales, the sort of broad umbrella of defamation. Now, defamation could and does, I think, protect your self-esteem, but that's almost a byproduct. It's not the front and centre of what we're thinking about. By and large, the law of defamation protects you against reputational damage, yes, but there is a bit of a sting in the tail. So, as lots of you will know, there are two subcategories of defamation in the law of England and Wales. There we have slander, which deals with transient temporal expressions. So basically the spoken word or rude gestures. You can, in some circumstances, imply something about a person by using gestures rather than words. I'll let you use your imagination. I have no intention of demonstrating. And also we have libel, which deals with recorded, non-transient, permanent expressions. So writing, text messages, recorded messages, things like that. And when we're in the realm of slander, there are a small category of types of slander that are what we call actionable per se. That means the fact that you've had this untrue thing said about you and it's reputationally damaging is good enough. But in most circumstances, it's only something that you can sue about if you can show economic damage. So the law of England and Wales is much more interested, yes, your reputation's been damaged, but how much harm have you suffered in a way that we can quantify in money? We're worried about that. It has more of an economic tinge. And historically, right back in the law, I mean, admittedly, this is in the early modern period, but there's a famous statement from a judge saying that they didn't like the idea of a claim founded, quote, on mere breaths. Yeah? It was basically get over yourself. Have they hurt your body? Have they taken your stuff? Well, no, then stop whining. Get out of my courtroom. And although we've moved on from that, I think we can see the footprint of that attitude, if that makes sense, in the law. I think defamation, it's now governed largely by legislation, but we keep tabs on it. We don't let it get out of hand. We're not keen on it. There are other mechanisms that in some ways control freedom of speech. There's malicious falsehood. Again, that's absolutely economic in focus. There's breach of confidence, which is a little bit different, and that sort of protects privacy, and that's been heavily influenced by Article 8. But by and large, the overarching approach is quite different in the two contexts. I think in Spain, the idea of things like honour, the idea of self-esteem, an attack on a person's sense of identity, that sort of focus is much stronger. In England and Wales, reputational damage, yes, we do. We do allow an action, but it's much more closely related to things like economic loss. Now, I'm going to briefly talk about the joys of buying a house with a degree of trepidation, because usually anytime you mention the dreaded C word, conveyancing in this jurisdiction, if you're a lawyer, there'll be a queue of people who've got stories about how long it took their house sale to go through. All I can say is, yes, I'm sorry, you try working in a law firm and dealing with the property department. But as a general rule, I think our point is that again, you see a more libertarian and a more individualistic kind of pattern. The law in England and Wales is much freer when it comes to allowing people to get the best bargain, even if it means that you're treating someone quite badly. So basically, the way it's set up permits what is sometimes referred to as gazumping and also something called gazundering to happen quite easily. So gazumping effectively is when you've agreed to sell your property, but someone comes along and offers you even more money, so you dump the first buyer, basically. You say, sorry, not selling it to you after all, I can get more money over here, goodbye. Not only is this very emotionally distressing, you often lose quite a lot of fees if you're the person on the receiving end. It's horrible and it's not nice behaviour, but it happens a lot because people are money driven and nobody's stopping them. Gesundering is slightly rarer, but also nasty, and in some ways even nastier. So this is when you've agreed to buy a property for a certain price. Just before you're about to exchange contracts, one of the parties says, actually, I'm going to lower my offer. I'm only prepared to pay you this much instead of the amount I originally said, and just hoping that you can basically blackmail them into going ahead. Not nice at all, but is quite possible. Now in Spain, and depending on how you do it and when you do it, that there might be various repercussions, but the most, apart from some possibilities in some circumstances where you might trigger civil and criminal liability, but mainly it's dealt with by effectively having a deposit at a much earlier stage in the process. So if you were to try and do that, you would suffer so much economic loss, it wouldn't really benefit you. I mean, you could if you were really unlucky and you're buying a 2-bedroom flat in Malaga, if Donald Trump or someone decides they really want it and they can offer such an obscene amount of money as to cover your loss, well, you could still be unlucky. But for obvious reasons, that doesn't happen every day. So it's a much less common reality. And I don't know if, Javier, would you like to do the last bit or do you want me to? You think I'll carry on with the flow? And
Well,
you'll do it. I'm happy.
no, just to say, oh, thank you, Helen. No, that's very kind. Well, just to say that obviously I hope we have highlighted some key differences between both jurisdictions. I think the sort of broad statements give rise to obviously disagreements, and that's part of academic and or life in general. Then obviously you can take a different approach, or your take can be completely different from ours. I would say that generally speaking, we would regard English and world law as more individualistic and libertarian in its approach to human interaction. And we hope we have demonstrated it today by looking at these examples. We would argue that, on the contrary, Spanish law is not better or worse, but tends to be more collectivist and communitarian in their approach. There are fantastic sociologists of religion that also claim that there is a religious reason, and there are some analysis about the fact that the Roman Catholic countries tend to be more communitarian and Protestant countries tend to be more individualistic. I think that's highly problematic. First of all, because I would say I would struggle to label the UK as a Protestant country, because some of my Anglican friends and colleagues regard themselves as Catholics. And I know in Spain we're very simplistic and we would just say, oh, the Church of England is Protestant, to the dismay of many of my beloved Anglican friends nowadays. Therefore, and also I would say that in England, that the religious dimension is problematic also because obviously the common law system is deeply rooted in these events from 1066 onwards. And at that stage, obviously, we were a Catholic country. Therefore, I think I wouldn't say so much the religious element, even though some of my peers refer to that. I would say these are the social aspects. It's been such a privilege for both of us to be here with all of you, and we look forward to your questions.
Absolutely. Thank you.
Okay, thank you both for such a rich, interesting, and provoking discussion. We have covered a large number of matters, from constitutional codification, legal traditions, to duty to restraint, family expectations, honor, and even something. I love this this word. It's very weird. What I think is how really come through this disagreements is that the constitutional culture isn't just formal rules. It's about values and how societies understand responsibility, freedom, family, reputation. It's what I have sometimes. The differences between jurisdictions reflect profound philosophical commitments, and sometimes it's simply product of the history. Yes, it's true. Um, We now, I love to open the floor to the questions. So please do raise your hands. And if you could keep your question concise, much better. So we'll have allowed to other people to main questions to the audience. So first,
Here's the mic.
no, I think
We're gonna try.
we have a couple people.
One minute. We'll come over.
Further, yeah. Thanks. Okay.
Hi there. There's this theory amongst a lot of prominent Brexiteers, which I don't necessarily subscribe, but that English law was so incompatible with European and in particularly French law that something like a separation English and European legal systems was bound to happen, and in fact that Brexit was destined to happen because of audio filter.
I mean, I think it's a very interesting thought. I can see where it comes from, but I think it's essentially misguided at the root. I think it misunderstands the relationship that is meant to exist between the law of the European Union and the way that that law gets translated into the law of local jurisdictions. And the irony is, some bits of the law that arguably were the least effective fit and have caused the most problem, cough, cough, data protection, we've still got. So if that was really what was driving it, then it's odd what has and hasn't evaporated, would be my take on it. I don't know what you...
Yeah, I think that's a fantastic question. I know that many Brexiteers have referred to that. I would strongly disagree. And I think, well, it's also very much driven by this idea that Europe was, or the European Union was a reality completely detached from here, not recognizing that many of the actors and bodies that were taking part in the different organizations were British nationals to start with. That's one issue. And I would say that the clearest example of how things work for many, many, many years was the compatibility between two principles, which in principle, and that's quite redundant, were antagonistic to each other: supremacy of European Union law on the one hand and supremacy of UK domestic law. And I just love the fact that the UK is such, in that sense, such a very articulate and very ingenious and very clever, witty country that was capable to reconcile with each other two principles that, to start with, were really antagonistic with each other, and in the end they worked very well. Therefore, I think the departure was motivated by very, very, very political reasons, but not because the UK didn't fit into the wider European legal family.
Yeah. Okay. So we have another question.
Thanks. First of all, Helen, can I praise you on your punctiliousness in saying England and Wales?
Oh.
You are an example to so many others. My question is this. You talked about the UK not having a codified constitution. I'm a common lawyer who has practiced in a jurisdiction that does have a written constitution, and I want to challenge your assertion that we have an uncodified one, because is it realistic to speak of a country having a constitution in the sense that it is understood by the democratic legal world if I cannot go to a court and get that court to say to the legislature that what it has done is invalid? In Gibraltar, where I practiced for 10 years, I could do that. In Spain, I can do that. In Ireland, I can do that. I can't do that in the United Kingdom. Would it not therefore be more honest to speak of us as having constitutional arrangements rather than putting the label constitution, which doesn't really fit?
I mean, this is my passion, but you refer to Helen, therefore I think you should have.
I think, as usual, we'll both answer. We're kind of legal push me pull you, aren't we? Really, the little goat thing with two heads from Dr. Dolittle. I mean, I think obviously you can talk about what terminology you prefer. And I think the author that Javier spoke about, David Feldman, does make a good point that sometimes we get very wrapped up But the reality is that even with a codified constitution, there are lots of things that exist out with the document, and we have lots of legislative bits of the constitution here. I would say that there are bits of the constitution that are enforceable in courts, and there always have been. Enter Carrington, for instance. So I would say that the fact that we can point to some things that you can go to a judge and say, hey, look, our constitution says you can't do that. There are fundamental baseline rules. But I do take your point, and I think it's a very interesting conversation to have about useful terminology. I don't know what you might want to.
Yeah, no, absolutely. Codification, no codification. I think these labels tend to give rise to a disparity of understandings, and I much prefer it. I mean, you would use constitutional arrangements rather than uncodified. I think I would wholeheartedly probably concur with that. I wouldn't have an issue. I think it's a terminological distinction. I feel much more comfortable with your statement of constitutional arrangements rather than unwritten, which is what we always tend to say in the UK. I think that's outdated. I think the UK constitution is overwhelmingly nowadays, whether it's codified or it's constitutional arrangements, is overwhelmingly written in 2026. Therefore, yes, I think these are very, very stimulating and theoretical distinctions, and I would agree with you and also with David Feldman and Helen. Yeah.
Try to be concise because we have many people who wants to speak.
Okay, I'll try. Thank you for a very interesting talk. I had one other suggestion for the differences between Spanish and English laws, which is that maybe, and I worked in Brussels for a while, so I could saw some of this playing out. The UK is more pragmatic. England is more pragmatic. So there's no need you don't pass a law if there's no need to pass a law. So maybe I suggest that one reason we haven't got a Good Samaritan law is because there's no need to, because you didn't have cases of people sitting down watching somebody else drown in a shallow pool. So that's why there was just no need to pass that law. And I suppose the question would be, are you aware of any cases in the UK where people just don't behave like Good Samaritans? I mean, is that a real issue? And in Spain, how many convictions are there? How many prosecutions are there for this Good Samaritan law? Is it just symbolic, or does it reflect a real problem?
I mean, I think I wouldn't know about the Spanish statistics. I think there certainly have been debates in various contexts about the lines that you would want to draw. So I can think of various cases about whether or not it was appropriate to prosecute someone for manslaughter, as to whether they'd assumed enough of a duty of care to a person who wasn't designated a vulnerable adult but was in the same house as them. And the debates that came in those cases, I would suggest, indicate a sense of discomfort with the idea of having enforced good behaviour. And that's something that matters. Way back in the 19th century, for instance, Lord Macaulay, actually talked about this and was debating it with his friends in the Athenaeum Club. And they were very much of the opinion that they didn't want to live in a world where there was no room for goodness. So it's certainly something that people have thought about, and it's certainly something that they have litigated about. But as Javier explained, and I would agree, I think it's also a question about the purpose of law, because I agree with you in terms of social norm. The social norm is you help. And I think it's a question partly of, do we want that social norm to have the coercive force of law or not? I think there is evidence we have thought about that in England and Wales, and we've generally said, no, we don't.
No, I thought, I thank you for that. It's a very, very interesting addition to what we were saying, and I'll definitely bear it in mind in the future. I will say that one of the reasons my story, you probably don't need to know the story of my life anyway, but I was going to say I decided to stay in the UK also in 2001 because I absolutely fell in love with the legal system and the academic model. And I was planning to be here only for 6 weeks, and it's been 26 years of my life now. Therefore, I love English law. I've always thought it was very driven by pragmatism amongst. I would say that the last 5-10 years make me feel that pragmatism as part of this albumen or white of the egg has been very much replaced by ideology in many ways. Therefore, I think we are losing that pragmatism as a country. And as a result, I'm feeling slightly sadder about that because it's one of the strengths of the UK that I fell in love with passionately, I must say.
No, I just wanted to. Yes, because another, in my view, another important difference between civil law systems and common law has to do with the way judges are appointed, the background of the judges. There are normally civil servants in continental and civil law systems, whereas in the UK, normally you have practicing barristers and solicitors with a previous experience. Can you perhaps explain a bit more about that, elaborate a bit about that? Because I think it's quite relevant. I know systems are merging because in Spain we now have the possibility of, appointing practicing lawyers as judges, but it's still something that is not the general.
Yeah, I mean, absolutely.
Interesting now, but
No, I was just going to say, I think it's interesting because it's something that we've disagreed about, or at least it's something I've expressed my shock to you
Yeah.
about the idea in Spain. How can you possibly have someone in their 20s who maybe have passed lots of exams but have never actually had to stand terrified in front of a judge, explaining the mess they've just made of it to a client, and you let this person be a judge? And
also the same in Italy or in France.
but you always
Yeah,
you
I would
always talk
say.
about my shock, aren't you?
Yeah, no, I don't. Obviously, we are no matter how many years I live in the UK, I suspect my legal mindset is deeply rooted in my continental or civil law tradition. Therefore, you are at times between a rock and a hard place, and you are very torn. And I see benefits in both systems, but obviously, does everybody know how judges are appointed in Spain here? No? Probably we should say it. Yeah, you have to take an exam when you finish your first degree. After a few years, you do an exam which is at the state level, fiercely competitive, like maybe 50 positions for more than 4,000 candidates in the past, and there are fewer apparently now because fewer people want to pursue that path. But it's still absolutely commendable if you become a judge. In Spain, you can do it at a very early age. One of my closest friends became a judge at the age of 26. Obviously, that's frightening, and Helen was horrified at the age of 26. I think she's very, very bright, and I think she gave made fantastic decisions at that age. I think the system is very meritocratic. It doesn't really matter where you come from, who your parents are, lots of things, which I would really, really value. But at the same time, I think the English system is, in that sense, much stronger because when people reach that level, have a much higher degree of, and I think in the last few years, luckily, the United Kingdom has done loads to overcome, in that sense, that lack of meritocracy in the past. Therefore, maybe we have the best of both worlds. What I would say is both Spain and the United Kingdom share fiercely the idea of independence of the judiciary. I know in Spain now this is very contested. I just want to say the judiciary is not just the Supreme Court or the Constitutional Court. And in fact, the Constitutional Court, strictly speaking, is not. Therefore, when people say there's no independence of the judiciary in Spain, I think that's very offensive. I know lots of judges that on a daily basis are doing an amazing job in Spain. Then I wouldn't want to have a system with respect. I love the US, etc., but I don't want to have a system in either the UK or Spain like the American. Then I don't think they are that, in that sense, that different, despite the access to the career.
But we have another. No, this.
Hi, I wanted to pick up on the issue of reputational damage. I'm not a lawyer, but one of the things that I understand is a big difference between the libel systems in the US and the UK is that if you bring a case in the US, the person has to prove that which way around is it? The person has to prove that what they said was true, and if in the UK, the person has to prove that it wasn't true. So if somebody accuses you in the UK of something, in the UK, you have to defend yourself. So I'm asking in Spain, I understand this issue of reputational damage is dealt in a different way, but if an accusation is brought, what is the argument? Does the person who brought the accusation have to prove that it's true, or does the person who's accused have to prove that it's not?
I mean, by and large, in both the UK and the US, the burden of proof to kind of, I mean, obviously it's quite oversimplistic, but basically the burden of proof is on the defendant to demonstrate the truth of their statement in both. But it is also true that in the US, there's an even stronger protection of freedom of speech. Um, in the Spanish system, by and large, similarly, you need to establish that what you have said is correct. If you have said something that is damaging, it's up to you to demonstrate that you had good reason to say it and that you had good evidence. In terms of what this sort of requirement and the threshold are, there are differences between the different ways in which you might deal with the improper speech, if I can put it like that. Does that make sense? But by and large, because it's very difficult to prove a negative, and also if you have established, if you've got to the level of establishing in any sort of the three jurisdictions that speech is damaging enough that the legal system will potentially intervene, then it's on you to justify why you have put that into the public domain.
I thank you for the presentation. I would like you to explain, especially to Spanish people who hasn't studied law, what tort law is, because it's an area very different from Spanish law. And I think many people here doesn't know what the word tort means. And also, you have spoken about this previously, but from now on, because the UK is not anymore in the European Union, do you think now the difference between civil law and common law is going to be much wider, and especially is going to be a drive for cultural differences, so a way to differentiate us much more?
Okay, no, that's so good. Yes, my apologies. Tort law. That's the second area of law which I love most after constitutional law. I owe it to my co-author because I am a constitutional lawyer, as I said, but I have become absolutely besotted with tort law. I don't know, well, I know why. I think it's fascinating. It's very interesting. And I always say, well, currently as head of a department and so on, I cannot teach. But as soon as I'm back to my role next year, normal one, I think I would be very happy to deliver some lectures in tort law because it's very exciting. Tort law is really critical in English law, and I would say, you could say for Spanish, for those of you who are from the Spanish tradition, it would be the equivalent to responsabilidad civil extracontractual, which when I was a student in law in Cadiz in the 1990s, we didn't study it. And now I talk with some of my academic colleagues in Spain. What's your name? Ismael. And they say, no, we just teach a couple of sessions. There is one particular faculty that is very powerful in that area.
I studied technically 30 years ago for a Patrimaster tort law. But it was just there, I think, at the time. I don't know now.
Then it's the degree of liability that is obviously triggered by actions when you don't have a contract in the civil sphere. On the contrary, obviously, the breach of a contract, that's contract law. That's an oversimplistic distinction. And I would say, well, Helen has given an example of, there is the whole notion of assimilated law now as a result of our departure from the European Union. And well, there were some terminological changes. I think it was first assimilated, now integrated. But the truth is that an outstanding, remarkable percentage of the laws that we have prior to leaving the European Union have now become part of UK law. And we are not deviating that much from it. And I would say that, generally speaking, I mean, if anything, what we have discovered in our research is that some of the changes, and this is coming from somebody who loves the UK with all his heart, but I just find it very sad that, for instance, in terms of, employment regulation can be an example, but also the whole issue with climate change and also ecology and water pollution and so on, the UK has been making some decisions that are detaching it from what we have in the European Union, and I think, in my view, that's been for the worse. But generally speaking, a drastic change, I don't think that's going to happen. And the UK is part of the European family and will remain part of this European family moving forward because we share so much.
I think it's time to conclude the Q&A. So I was finalized with a simple question. If you could borrow one legal principle from the other system, what would it be and why?
You
What would I like from Spanish law?
right to honor?
No. No, not the right to honor, I don't think.
I will start. I will
Okay.
to give you some. I will. I mean, this is. It's probably part of this experience in the UK for the last 2 decades. I generally think that the freedom of the person to decide where his legacy will go in English law is correct. I don't think being somebody's son should entitle you to expect to inherit your parents. If you have been a good son or a good daughter, that's fine. And I think in the vast majority, this is what we were saying earlier on. The vast majority of British people decide to leave their goods to their descendants, not to the donkeys, as Helen was saying. I think that's, well, giving a part of your goods for the donkeys is fine. But I mean, what I'm trying to say, yeah, I think the system in Spain is unduly rigid when it comes to freedom of wealth.
Yeah, I mean, actually, I think the thing that I would appreciate would be actually to codify some of the important bits of the Constitution. I think things like the powers of the monarch, I think things like the process of appointing the Prime Minister, I think leaving that vague is dangerous. And I think given that Europe is in general, including the UK, tending into more extreme political territory, I think not making sure certain things are safe is really dangerous. And I think those kind of attitudes to constitutional protection that exist in Spain are really laudable, and we could do with them here.
Thank you very much, Javier, Helen. It was a pleasure having you in this conference, this venue in Temple, so we can waiting for your book and very interesting because law and supernatural. Totally looking forward.
Oh.
Yeah, thank you very much. Thank you very much, Toby.
Thank you.